non-jury trial. The subject is pretrial statements. The separate property that's involved must be listed. Often a client will say to you, well, it's my separate property. Do I really have to disclose it or list it? Yes, you do. And the way that you do it is to list it in this statement. And if there's going to be an issue of separate property, it's going to be joined at that stage, so you'll know it's coming. The community property must be set forth with any obligations related to it, and if there's going to be any appraisal testimony, or if there's going to be appraisal information, attach the appraisal. This is the beginning of the process of discovery in this type of a case that gives the other side what they're actually going to be doing at the time of trial. It's out there. Moreover, when you get into that trial courtroom, your case is presented. It's difficult for a client to see their life reduced to 4 or 5 pages of typewritten statements, but that's what the family law practice does do. It tends to reduce the entire life to date into a statement of issues, assets, and liabilities. Funds that are held by other parties must be disclosed. If there's tracing, and again, the issue of tracing moves in and out of family law with a great deal of recurrence. Sometimes you're told that this is a key issue, other times the case will come down and blow away the issue of tracing. Current obligations must be listed, and though it is not attached to the sample that you have, a current financial declaration must be prepared so that you're ready to go into trial with all of the current financial information. This document is going to have some significant changes from the initial one that you have filed at the time of that order to show cause. Because now the client has learned to live within the budget or within the money that's provided and what's left after the earnings are distributed to the family. The statement is going to be your best presentation of your case. It should be used to present to the court what you know about the parties and what you want the court to know about the parties. While often attorneys view this as something that is swept aside, it's not to be considered, and then when they get into trial, they'll really show the court. You often do not get to that stage because, as you know, you get into a courtroom with a judge dealing with a family law matter, and the first thing you hear is, well, what's this all about? What are the issues? What's your position on the issues? This statement should put you in a position to say, Judge, our positions are set forth in our pretrial statement. I think that there's going to be changes through the entire Bay Area in the practice of family law, and eventually you're going to get to a point where the matters can be almost submitted with very few real discrepancies in the facts. The appraisal information, the evaluation of the relationship of the children are going to be part of the various pleadings that get to the judge. In Alameda County, I envision a series of settlement conferences that are going to require you to focus in very specifically on an issue, and hopefully the judge is going to give you a view that will allow you to put that issue aside and consider it as one of the settled issues. I asked at a current hearing, actually a meeting that they had, to try to discuss the new approaches in Alameda County, and when we talked about what is a trial going to do, the judges are really unclear because we're still experimenting with this system. But I think that the elimination of a trial is going to be something that's going to take place at every place in the Bay Area except in the smallest of counties where they cannot focus in one judge to keep totally abreast on the development in the family law field.
I don't know if Lauren expressed it directly, but it bears emphasizing in any event that not only is the pretrial statement and request for admissions desirable in a domestic relations case in the Bay Area, but you may not file your at-issue memorandum. That is, you are prohibited from becoming at issue until you have filed that statement in the Bay Area counties that subscribe to those uniform rules. Our next subject is readying the case for trial. There's a checklist in your principal materials, that is the thicker book at pages 21 to 24, and if you follow that checklist, you shouldn't ever arrive at the courthouse suddenly discovering that you are there with some critical omission. There's also a sample trial book set out at pages 25 to 36, I think, in your material. A lawyer's trial book is a game plan, and it can be just as skeletal or as elaborate as the particular case and your own needs dictate. Some cases, especially some short causes, may be so simple that in their presentation they call for virtually no notes being referred to or guidelines of any kind. But it's a good practice to make a trial book and get in the habit of developing one in every case that you have, no matter how simple the case may seem. The development of the trial book will usually be most painless and most profitable if you start from the very beginning with your first interview with the client and build it all the way through. The style and the detail, as I said earlier, will depend largely on you and your needs and on the nature of the case. But I suggest that you make it up in a loose leaf binder because the proper order in which you will want to set it up may not occur to you until you're well along in discovery or even after you've completed your discovery and are into the later stages of your preparation when you know the most about the case. What about the development of the oral evidence that you're going to present at trial on?
The preparation of oral testimony requires you to take that step back and try to view the case as the judge is going to see it and perhaps as the other side is going to be hearing it. I recently tried a business case and one of the main issues involved two different conversations that took place between two groups of people. And each of the parties to each of those conversations had had their depositions taken, and like that old childhood game, it didn't seem like any of them were at the same place at the same time until you took that step back and tried to visualize who was saying what at what time and what did you hear that was inconsistent or consistent with what someone else said. As you visualize how that took place, you begin to develop the preparation for that testimony to be brought into court before the judge. And remember, we are dealing with a judge. If we were talking about a jury case, we're talking about a substantially different presentation of the evidence. In a family law matter, when we talk about the necessary witnesses, the single most important witness is your client and the other side. The short cause matter has substantial limitations. You must use your time efficiently, and you must try to consider what is going to be the smoothest development of your case. Unfortunately, a family law matter does not make for the smoothest trials because often the issues are interrelated. So if one issue goes one way, a number of things follow from that. So you often have to present your testimony from your client where you first develop your facts, then you develop what it is that your client wants to have the court conclude as a result of those facts presented. So in effect, your testimony goes forward as to one issue, deals with the alternative, and then moves on to the next issue. The preparation of direct testimony requires delivery of facts in response to questions, not the delivery of facts contained within the question. The witness client must know the outline of the questions, and they must be prepared in a way that is consistent with how the client experienced the facts. If the deposition of your witness has been taken, the questions must be developed so that your client knows what is likely to be the cross-examination they're going to experience as a result of the testimony that they gave, either by way of a deposition or in response to interrogatories. You have to show your client how to handle the cross-examination, I believe, at the very first time that the client is testifying as to that issue. You know what's going to be happening when the issues are presented to the court on cross. You must deal with it affirmatively at the time of direct. If you don't, the meaning is going to be lost to your client, and it really becomes a matter of just rote memory and not the real experience of the facts. Cross-examination, on the other hand, is a lot more fun. You can lead your witness. You really should know what the answer is going to be to those questions. It's an old rule, but it's still a good one. You don't go and ask